said on March 20th that it would be at home online FRQ 45 minutes. So that's all we've been told. They said they would be releasing specifics on April 3rd. So as soon as we know, we will get that out to you. So again, as of right now, we're basically in the same boat that you are. We do not know like what is happening with College Board. Just be mindful that you should keep practicing all the units that they've told you to practice. With AP Government, the units that are going to be covered on the exam are units 1 through 3. It will not cover units 4 and 5. So that means these are the 3 units that will be covered: Foundations of American Democracy, Interactions among Branches of Government, Civil Liberties and Civil Rights. And then these 2 bottom units are really like the, I think of it as it's like the AP Government is going to be covered. The politics really isn't going to be, because that's what 4 and 5 is about. But those are the 3 units that will be on your exam. Okay, another question. Do you know if it's going to be text box that we submit for the AP exam or like a picture of our written work? I know I saw in those updates that they said you could take a picture of your written work. And I also saw that they're providing an online way for you to type. So yeah, like Japesh said, I think you can do both. Again, really all we know is what's in that update that has been posted by College Board. So if you've read it, that's all we've read too, and that's all we know. Yeah, so you'll just have to keep looking on Trevor Packer's Twitter or on AP Twitter or all of those different resources you can get just to stay up to date, because as of now, we don't know anything more than you do. Okay, so before we get started with like the actual content for this stream, are there any questions yet? I know I've seen a lot in the chat. Are there any other questions? Didn't Robbie May quit? He told his government class. We were told that he's taking a break. I don't know anything past that. But yeah, that's all I know. Okay, so FRQ3 Supreme Court. Now, your Supreme Court case FRQ, honestly, I think this is the one that you can study the most for on the AP exam. This is the FRQ that if you've really put in that work and studied what College Board says you need to study, you will do great on. Because what you're doing in this case, or in this FRQ, is that you're comparing one of the required cases with a case that's presented to you on the exam. So we'll look at a sample one later in this stream, but there are 15 required Supreme Court cases. So in my opinion, you should know those in and out. Okay, you have probably been studying those throughout the year in your AP class, and you can find them online and stuff. However, you should know these cases in and out, facts about these cases. What is the constitutional issue that revolves around these? What was the holding? What were the constitutional principles that were involved? Those will be compared to a non-essential case that is presented to you on the exam. So the non-required or non-essential case, they will give you all the information you need. They give you a huge paragraph with all the information about it. Basically, you're comparing your knowledge of one of those landmark cases with the knowledge or with the stuff that's presented to you on the exam. So it is essential that you analyze these cases in depth before you go into taking that 45-minute FRQ in May. So for each case, what I would recommend knowing is a short summary. Maybe not necessarily a date, but it provides contextualization. So if you've taken an AP history class, whether that be world history, European history, US history, you know on your DBQ, even your LEQs, you need some sort of contextualization, right? You need to provide that. Knowing that date or knowing that short summary, even though it's not going to earn you a specific point on the AP exam, it is going to be beneficial because it'll help you put stuff in perspective. You should, however, know some specific facts or some specific names from that case. Normally, this is pretty easy because if you have US versus Lopez, you know Lopez is one of the people, and you can probably elaborate on that. However, I would recommend knowing 2 or 3 facts about that case, specific facts. Yes, the slideshow will be linked at the end of the stream, so it will be linked as part of the replay. The other thing that you should know is the constitutional issue. So you should understand what specifically in the Constitution a case relates to, okay? So with Brown versus Board of Education, you should know that it relates specifically not only to the 14th Amendment, but to the Equal Protection Clause, okay? So you should know specifically what constitutional principle, what thing from the Constitution can you point to that this case relates to, okay? And then know the holding and the majority opinion. So this is the most important part because it tells you what happened in the case, and that's something that you can write about in your essay response. Okay, so what we're gonna do, just really quickly, in this stream, again, if you guys are tuning in, hopefully it shouldn't take that long because most of it's going to be spent writing our own FRQ. So we're going to go to another document and then write the FRQ. But what I'm going to do now is go through each of these cases. We have separate streams that are linked within our fileable database where you can go through, and I'm the one that did those as well, where you can listen to the stream that goes in detail about the 15 required Supreme Court cases. So since this is not necessarily that stream, I'm not going to go through and highlight each one of those cases in depth. I'm just going to provide you a summary. And then I will do an in-depth analysis of Brown versus Board of Education, which is the FRQ that we will be writing, so that you guys have some contextual analysis or contextual background before we write that FRQ. Where would you find that again? Or what are you talking about with where would you find it? The streams. Okay, so if you go to fileable.me and then you log in, so I'm assuming if you're in this stream, you've created an account. Once you go into the account, like you click on social science, which is like the broader category, click on AP Government, then you just look through the streams. There would be one that says required Supreme Court cases, and you'd be able to find that. Yes, there is a stream specifically for the required Supreme Court cases. So that is why I'm not going to go through all of these completely in full detail, because there is a stream already that's like an hour long just on these required Supreme Court cases. Okay. So the first few cases that we're going to talk about are cases involving federalism. So the first one is the McCulloch versus Maryland, and this was the one that involved the supremacy clause. It said that Maryland could not tax the federal government, and so basically it's the state can't tax the federal government. Additionally, what it said was that a national bank could be created, because that was kind of the issue that was at stake with that case. Next case is U.S. versus Lopez. The main clause, remember we were talking about one of the things you should be knowing for your AP exam is the required clause. The one that deals with U.S. versus Lopez is a commerce clause. So basically what it said was that Congress can't use the commerce clause to justify that, banning guns in a school zone and justify making that a federal crime. So that was the main thing that was at stake with that case. The next case we're going to talk about have to do with the Bill of Rights. So, yes, okay, thank you, Dakota. So, the next case we're going to be talking about has to do with the First Amendment. So, Engel versus Vitale. Does anyone know anything already about Engel versus Vitale? Because this was on one of the practice FRQs that College Board released. Yes, car owner virus. It is called Must Know Supreme Court Cases Part 1. But does anyone know anything about Engel versus Vitale? Yes. With the Establishment Clause. It also deals with the school sponsorship of religious activities, specifically public schools, because public schools are funded by the federal government. Basically what they said was that even if it's a non-denominational prayer, any type of prayer can't go on in a public school or school operated prayer, just because that seems like the federal government is endorsing a religion or even the presence of religion. So the argument people made was that, okay, even though it's a non-denominational prayer or not specific to a certain religion, it is still endorsing the presence of religion. So people that are atheists might not agree with that. Okay, so that was kind of the reasoning behind that. The next case is Wisconsin versus Yoder. This had to do with the other main clause in the First Amendment. So the free exercise clause. This had to deal with Amish students that were attending school past 8th grade. Basically what the federal government said was that the interest of the people in terms of the free exercise clause is more important than the federal government or the state government's requirement to keep kids attending school past the 8th grade. Okay, the next case is Tinker versus Des Moines. This has to do with symbolic speech. So basically there were a few students that were protesting the Vietnam War with wearing black armbands, and this was considered symbolic speech. The principal kind of said they were going to be suspended. The kids took it to the kids and their parents really took it to the Supreme Court. Supreme Court says, yes, this is allowed because it's not disruptive to the school environment, and symbolic speech is still free speech. Key phrase kind of you hear with this is a student's rights doesn't end at the schoolhouse gate, something similar to that. Basically what it's saying is that students do have rights even when they're in school, which, you know, sometimes people disagree with, but that's what this case was about, okay? Does anyone have any questions so far with the cases we've covered? All right, so the next case we're going to talk about is New York Times Company versus the United States. So does anyone know anything about that case? Right, Pentagon Papers, and it happened during or had to deal with what administration? Yes, Nixon, Watergate. Oh, great job. I really love the participation, guys. Normally some of these streams, they have like 5 people, nobody participates, 19 people, and all of you guys participating is really amazing. So with New York Times Company versus the United States, it bolstered the freedom of the press, and it basically said that even when involving national security, there's a heavy presumption against prior restraint. Yeah, so the next case is Schenck versus United States. This basically said that speech creating a clear and present danger is not protected by the First Amendment. So do you guys remember what the situation was with Schenck versus the United States? Right, the Espionage Act. And what did the person do? What did Schenck do? It was Schenck and I believe one other person. What were they advocating for in the stuff that they published? Yes, he passed out these leaflets or pamphlets protesting the draft. He said it was like a violation of the 13th Amendment. And what the Supreme Court said in their decision is that this like really might have convinced people to disobey the draft, which could be dangerous for the country at the time, especially if it's in war. So that's why it created this clear and present danger, that kind of phrase. Basically, that's not protected by the First Amendment. Okay, so the next few cases we're going to be talking about have to do with selective incorporation. So what is selective incorporation? Does anyone know? They can choose, so like piecemeal, it happens one at a time. Let's the amendments apply to states. Yes, due process clause, all of those, great job. Car owner virus and Allison, great job. Yes, so the selective incorporation cases, what selective incorporation is that with your constitution, all of those amendments like originally apply directly to the federal government. So that's a yes. We know for sure that those apply to the federal government. Piece by piece or case by case, these amendments become applied to the state governments. Just recently, like I think 1 or 2 years ago, the 8th Amendment was incorporated. So the cruel and unusual punishment. So this can happen, this has happened over a long period of time. So the first case we're going to talk about is Gideon versus Wainwright. If you haven't seen it, there's an excellent like documentary, docuseries, kind of like a movie. I don't know what it is about Gideon versus Wainwright. Great movie. Guaranteed right to attorney for the poor, even in state felony cases. Basically, Gideon was a poor guy. He couldn't afford a lawyer. And in Florida, under Florida state law, they only got a court-appointed lawyer if it was like a federal crime or a federal capital case or something. So because of that, he petitioned the Supreme Court, filed a writ of certiorari, and they heard the case, and they said through their ruling that yes, everyone is guaranteed the right to an attorney, no matter what type of crime it is. So this was like a huge ruling. It had massive impacts on the United States at the time. Okay, so the next case, Roe versus Wade. Does anyone know about Roe versus Wade? This one's probably, like you've probably heard of it, at least, even if not in AP Gov. Yes, the right to an abortion, and basically expanding on that right to privacy, implied right to privacy. The Supreme Court ruled that the right to privacy could be extended to a woman's decision to have an abortion. So abortions are legal in the United States. The next case, McDonald versus Chicago. Do you guys remember what amendment that incorporated? The Second Amendment, correct. Do you remember what it had to deal with, like guns? Do you know where it happened? Chicago, yay. Good job, Katie. So McDonald versus Chicago incorporated the Second Amendment's right to bear arms to the states. Basically, it's what you kind of see as a theme within all of these selective incorporation cases is that it's like they have to interpret it as an individual right. So almost in all of their rulings, they say, okay, the right to bear arms is interpreted as an individual right, and that's why it's being incorporated to the states. So there was actually a previous case with McDonald versus Chicago. I believe it was like DC versus Heller or something like that. And then in that case, the court had held that a handgun in DC violated the Second Amendment. However, now in order to make it applicable to the state governments, kind of a similar petition was done with the Chicago local government. That's how it became applicable to the state government. All right, so the next case we're going to talk about are cases involving the Equal Protection Clause. So remember, we're going to come back to Brown versus Board of Education in a little bit more detail, but does anyone know anything about Brown versus Board of Education? Desegregation of schools. And remember this one, the case that College Board refers to as the landmark case, or one of the 15 cases, is Brown versus Board of Education 1. So it's not like the second one that happened where they kind of said, okay, you have to desegregate now. This one is Brown versus Board of Education. Wasn't it last year's FRQ? Yes, it was last year's FRQ, which means that's the one that I wrote, and that means that's the one that we're going to be practicing. So sorry if you guys have done it before, but it's just a way for us to practice, and it's really easy because this is the only one that students have taken like in an exam session that has been released by College Board with scoring guidelines. So that's the one that we're going to practice. Yes, it had to deal with separate but equal, and it kind of overturned that, and it said separate can never be equal, right, with Brown versus Board of Education. Yep, so we kind of talked about that already. Remember, it had to do with the Equal Protection Clause. One thing we'll see with the FRQ that we practice, the sample FRQ, one of the questions literally is like, what clause of the 14th Amendment is it going to relate to? So yes, like you would need to know that Equal Protection Clause is it. Okay, question. Wait, but since Brown versus Board of Education was last year, won't it be unlikely for it to be on the AP exam this year? Well, yes, but College Board has also released like 4 other ones through their sample documents, and they have like 4 other cases. So it's really hard for us to like gauge which one they'll do. Yes, probably if there is a Supreme Court FRQ with Brown versus Board last year, it's unlikely that it will be this year, but in their sample exam, they released Engel versus Vitale. It's really possible that that could be the one this year because Brown versus Board was assessed last year. So it's just the way we're doing it is just for you guys to practice a way of writing these FRQs so that hopefully you know the skills and you know how to do it. Okay, does that make sense, Katie? Yes. Okay. So the next case we're going to talk about has to do with policy. So Citizens United versus Federal Election Commission. Honestly, for me, this is probably the hardest case out of all of them. Basically, what it says is that political spending by corporations is protected First Amendment speech. This one is one that honestly I think would probably be one of the harder ones if it appeared on the AP exam as a yes, it has to do with all of the things you guys are talking about. Corporations are like individuals, and that's why they're entitled to that First Amendment right. Yes, it is very famous. It happened really recently too. It happened only 10 years ago, I believe, 2010. But yeah, I would really make sure that you know like the specifics of the way this case works, because it's this case and then the next 2 cases that we're going to talk about too. So we're going to talk about this, then Baker versus Carr and Shaw versus Reno. Those 3 are probably the hardest ones for you to give you specific, or for you to have specific information about on the AP exam. So sometimes it's really a matter of making sure you know that information beforehand before you walk into that exam. Well, I guess walk into your room to take that FRQ online exam this year. Okay. Next case, like I promised, we're going to talk about is Baker versus Carr. So the next 2 have to do with apportionment, legislative branch. So Baker versus Carr has to do with the one person, one vote, and it opened the door to equal protection challenges to redistricting. And then Shaw versus Reno, which also kind of has to do with apportionment, says that majority minority districts can be constitutionally challenged if race is the only factor that is used in creating the district. So basically, if it can be basically clearly argued that a certain district was created just to like create that majority minority thing, like making sure that one race was clearly the majority of the population in that area, then it could be constitutionally challenged. Okay. So like I said, those last 3 cases that we talked about, Baker versus Carr, Shaw versus Reno, and Citizens United versus FEC, Federal Election Commission. Those were the ones that I think you should start preparing early on for in case it appears on the AP exam. Okay, and then the last one we're going to talk about has to do with the judicial branch, and it's Marbury versus Madison. In essence, basically what it did was establish judicial review. So this is something that you probably learned more details about in APUSH. Honestly, the biggest thing with this is that it established judicial review. Does anyone want to say what judicial review is? Maybe in the chat. Yes, review cases. And what can the, well, yes, review cases, but what else can the judicial branch do? What else can they review? Yes, they have the final say on constitutionality. Yes, the review power of the judicial department. Yes, so Allison kind of hit it right on the jackpot. It allows the Supreme Court to determine the constitutionality of the actions of the other branches. So those are the ones that you kind of need to make sure you know with checks and balances and stuff. I think that's still part of the unit that's tested on the AP exam. But judicial review is a key term that you have to know. Yes, great tip. I like your tip, Katie, for Shaw versus Reno. Okay, so like I said, the next thing we're going to talk about is Brown versus Board of Education, a little bit more in detail, just so that you guys are more familiar with writing it for the AP exam. Okay, so first slide, the background. So this is, like I said, one of the most famous cases in US history. If you had to pick a case that's probably taught elementary, middle, and high school, it would probably be Brown versus Board of Education. At this time, as you know, there was racial segregation of schools, and African American students had been denied admittance to public schools, or they were forced to go to a separate public school that were geared only towards African Americans. Many argued clearly that this was a violation of the Constitution. So what happened in terms of the constitutional issue was that it was an Equal Protection Clause issue. Plessy versus Ferguson held that segregated facilities were legal as long as the facilities were equal. Okay, so what, like you guys said before, what did Brown versus Board of Education do with Plessy versus Ferguson? It overturned it, right? So, like I said before, Plessy versus Ferguson was like separate but equal is okay. This said separate but equal is really never equal. Okay. Anyway, know that Brown versus Board of Education overturned Plessy versus Ferguson and held that segregated facilities were legal as long as the facilities were equal. Brown versus Board overturns that. Okay. Holding and constitutional principles. So, like I've said probably like 4 or 5 times in this stream now, the Supreme Court ruled that separate but equal is inherently unequal, and segregated schools that were allowed by the previous case were declared unconstitutional. Again, this had a major impact. It required desegregation of all public schools. Okay. Some of the key terms that you can kind of go back to with this case, judicial review, stare decisis, the concept of just like enforcement. Does anyone know what stare decisis is? Or want to explain stare decisis to the chat? Or have questions about stare decisis? Let the decision stand. I have no idea what that is. Okay, that's okay. So basically, the case established the principle that this case specifically said that it overturned a previous case, right? It overturned Plessy versus Ferguson. Stare decisis is kind of like, right, well, it's not really a tradition. Yes, it's a tradition to not overturn old cases, right? To stick to precedent. Yes, exactly. Looking back at precedent, looking back at what has already happened, and then saying, okay, since we said that there, it's also going to be applied here. Okay, in this case, they did not follow stare decisis. And it's a key place where you can look at a key case where you can say, okay, this is one example of the federal government or of the judicial branch setting new precedent, right? So now if you have a case similar to this, let's say for some reason, some state decided, okay, it's great to segregate schools. They start segregating schools. If that goes to the Supreme Court, they can now look back at Brown versus Board of Education as a new precedent case, right? Before you had Plessy versus Ferguson, which was complete segregation, and then Brown versus Board of Education overturned that. Yes, stare decisis is let the decision stand. This is one case where stare decisis was not followed, where the decision did not stand. Does that make sense? The next thing I want to talk about before we actually get to writing our FRQs are some of these clarifying terms. Okay, so I don't know where you like what grades you guys are in or anything like that, but like some of you might be in the IB program and taking AP Government as part of this. like or as separate, you have something that are called command terms. Okay, so those command terms are things that the questions ask, and you need to be able to give a response that meets the command terms requirement. Okay, so one thing that College Board really emphasized last year when this exam was released was that if it says explain, you need to explain. You need to explain how, why. If it says define or describe, that's less detailed. But if it says explain, like you can see in this description, you need to provide information about how or why a relationship, process, pattern, position, situation, or outcome occurs using evidence or reasoning. So kind of, I don't know, like I know we use this when I was like in elementary, middle school, they had like claim, evidence, reasoning, right? Your state, so state isn't one of these, or maybe define would work. That's going to be your claim. So you're just saying something, okay? Your claim and evidence together, that's going to be your describe. You're providing the relevant characteristics of a specified topic, okay? Explain is going to be like all three of those, claim, evidence, and reasoning. Another thing that you might have seen to compare this to, if you guys took one of the AP histories, if you might have heard ACE, the SAQ, answer, cite, and then explain, I think. So again, kind of the same thing. The A answer would be like define or state. A and C, so answer and cite, that would be like your describe. And then your evidence would also, adding the evidence in there would be what satisfies this explain portion. Basically what this like whole spiel is about is that if you only state something where you should have explained, you are not going to get full credit, and you might not even get credit for that part of the question. What would you say to use as evidence like Supreme Court cases? So here you're not really pulling from anywhere else. Well, I think the next slide has the like actual FRQ thing. It's going to give you a huge paragraph about another case, and then you're just pulling from your knowledge about the required case and the knowledge that they present to you with that paragraph. So no, you're not pulling in any outside evidence like you would for like a LEQ. Rather, this is more like a DBQ where they give you a document and then you're expected to pull in your prior knowledge to tie that in. Okay, does that make sense? Japesh. Would you get marked off if you do? So, okay, so I want you to do this. Give me an example of something that you would use as like outside evidence to support. Because if you think about it, it's kind of hard when you're comparing, when they tell you to like compare two cases, then it's kind of hard to kind of go beyond that, if that makes sense. Because they're going to be very specific about how they want you to compare it. Okay. With your other FRQs, yes, definitely you can use outside evidence. So even for your argument essay, if they end up doing that, your FRQ number 4, yeah, you could probably use some outside evidence or use outside political theories that they don't refer to. However, in the Supreme Court FRQ specifically, which is what we're talking about in this stream, it's really hard to pull in outside evidence, okay? So now what I'm going to do is share this link. So this is going to be a little bit of a learning curve too. I have not done this before, but now on the bottom of your screen, do you guys all see a green button that says writing an FRQ? If you do, if you could click that, yes, no. Do you not see it? Should be like it should be a green button at the bottom of your screen. I see people on there, so I'm guessing most of you can see it. What I can do though is, let me just go to this next slide. Okay, so there should be a green button at the bottom. If you can't get to the green button, just type that link in, the bit.ly thing. Yeah, it's, I don't know. This platform, the Crowdcast platform itself is not a part of Fiveable. It's just utilized by Fiveable to do our live streams. It's crazy sometimes, but I'll give you like a minute to get everyone onto the document. Yeah. Yes, Anonymous Sheep is on Google Docs. Great. All right. So what we're going to do is we're going to try and write this FRQ. Okay. So I'm going to go ahead and take over the typing. So kind of refrain from typing right now, but you can kind of keep tagging along with me in the chat so that we can explain, or you can put in bullet points. Feel free. Okay. So with Part A, it says identify the clause in the 14th Amendment that was used as a basis for the decision in both cases. So what I want you to do, I'll give you like a minute and a half or so. If you could read that paragraph that's on there about the Hernandez versus Texas case. So it's 9:40. I'll give you till like 9:41, 42 to read that, and then we'll start answering Part A. Okay. No problem, Katie. This will be back on your, or you can find the replay of this in Fileable probably later tonight. Okay, so you can always go back and watch the rest of the stream. Thank you for participating. Jason, I'm not sure what you mean. Are you talking about something specific? Or maybe that was with a previous. All right, so I'm gonna go ahead and start typing. If someone wants to put in the chat, what is the clause in the 14th Amendment that was used to make the decision in both cases? So both in Brown versus Board of Education and Hernandez versus Texas. Yes, the Equal Protection Clause, right? What would be the answer that would not get you credit? So they're telling you the yes, you are correct, the Equal Protection Clause, but what is the clause of the 14th Amendment that would not get you credit for this? Right, due process will not get you credit. So you have to make sure that you know which clause, even within an amendment, that these go with. So something that you could write for this clause in the 14th Amendment is used as the basis. Right, so remember those key terms that we talked about, those command terms, clarifying terms? This one says identify, right, for Part A. So identify just means state. So you only really have to just say it out loud. You don't, or not say it out loud, type it, write it, whatever. You're not really asked to provide a huge explanation. Yes, since it's identified, it's okay for it to be only one sentence. That's something I really want you guys to catch on to, is that if it says identified, they're not looking for a huge explanation. In fact, if you write a huge explanation and all that explanation is wrong, and your identify is right, you're kind of putting those points in jeopardy, okay? So I would make sure that if it says identified, just say it, okay? So we have Part A. Part A is easy. Now what's the clarifying term for Part B? Is it identify again, or what is it? Explain, right? So explain demands a totally different type of response. Explain requires that you actually like type, right, whatever, a lot, okay? So Part B says, explain how the facts in both Brown versus Board of Education and Hernandez versus Texas led to a similar decision in both cases. Okay, so what are some facts that you could include about Brown versus Board of Education that would tie in to Hernandez versus Texas, right? All right, remember, one thing that I want you guys to remember is that they have to see that you know stuff about Brown versus Board of Education, right? So they have to see that you know, you really studied for the exam, basically. They're wanting you to demonstrate your knowledge of that, okay? So and you guys can, I know I said before you don't type, but there's really not that many of you. So if you'd like, you can type bullet points or stuff like that for Part B. So what I can do here is do Part A. If you guys want to like put bullet points there and start typing of what you think would make a good response, and then we can craft our response together. Okay, so remember with explain, this should be like a decent paragraph that you're writing. And if you look at this, it says that in the ensuing case, Hernandez versus Texas, the Supreme Court ruled in favor of Hernandez, deciding that evidence of discrimination against Mexican Americans existed in Jackson County. The Constitution prohibits such discrimination, right? So the first thing that you want to start out with when it says explain how the facts in both cases lead to a similar decision is that you know you have to explain the facts of both, right? So I would start out like you are doing a normal essay and start typing with Brown versus Board of Education. So let's make kind of like an outline, okay? So you're going to talk first about your Brown versus Board of Education background. Okay, so some things that you could include in here were that African American students were being denied admission to schools purely because of their race. So you guys mentioned the race part. That's something that you could easily include here, right? And at that time, something else that you could think about, what was happening with schools at that time? Why was this case even there? You remember, you're trying to show that you know as much knowledge about the case at that time. Okay, let me get caught up on these. Okay, both dealt with issues of discrimination, fact that it's equal even though it's discriminated, separate but equal was still present in both cases. Yes, perfect, right? So I'm gonna go ahead and start typing down here. I'll say, okay, in Brown versus Board of Education, was that many African American students then in order to provide more contextual background, something you could easily say is that at this time, African American students schools separate from those that were white. And this prompted, so then you're kind of transitioning into what happened with the actual case, prompted several to sue under the Equal Protection Clause, right? Here you're showing that you know your constitutional knowledge in regards to segregation in schooling. So now you've talked about the background of the case. You've given a pretty good, solid foundation that you know what the case is about, right? Now you need to tell us what the ruling is. You need to tell College Board that you know actually what happened. What was a similar decision? So what are some things, either you can type in that outline that I created in the document or in the chat. What did the court rule? Like, what did they say? Segregation was what? Not equal, unconstitutional, right? So you could easily continue on here and say the court ruled that this racial segregation was indeed unconstitutional under the Equal Protection Clause. And what else what was that key phrase? That reflected the ideals from Plessy versus Ferguson. They said, no, that's not right. What was that phrase? Separate can never be equal, right? Yes, correct. I think I was the car person, right? Car virus something. Yes, car owner virus. Okay, so and then some other things that you might know from this case. So kind of making sure you highlight as much as possible is great. So you could say they highlighted possible problems, being psychological, that African American students face because of the implemented segregation. Okay, so I think we've given a pretty good background on Brown versus Board of Education, right? Now you need to transition into Hernandez versus into the Hernandez versus Texas. It's supposed to be a pun, like coronavirus. Coronavirus. Oh, okay. Ha ha ha. I get it. Good job. I did not get it at the beginning. I was kind of confused, but thanks for explaining it. Okay, so yes, they did highlight those problems, including psychological. That's just giving you more points from like their reader's perspective. Now they, in their head, they can be like, okay, this kid really knows what he's talking about, right? So, and yeah, sorry. Go ahead, like Anonymous Anteater is doing. Go ahead, you can type stuff in part C so that when we get there, we're ready, okay? So now you can transition into Hernandez versus Texas. Try to use these transition phrases that you learn about in English. This doesn't have to be like a perfect Englishy great response. It has to convey the meaning, but if you use these transition words, it's easy for the reader to spot where you're changing ideas and stuff like that, okay? Another thing, don't just write like in a huge paragraph because that just makes it hard for the reader. Okay, so similarly in Texas versus Hernandez, now you're providing context about Texas versus Hernandez. So what are some things you could say about that case? What was happening? Okay, so I'll just start typing, then you guys can add stuff as you go. Similarly, you could say in Texas versus Hernandez, there was a group that was being also being discriminated against. Mexican American. I clearly addressed that African American students were being discriminated against, and then down here highlight that difference or contrast. It's good to do that because when you do that, it shows again that you have that solid understanding of how these two cases relate. So you show that, okay, in both cases, there were groups that were being discriminated against. And in one case, it was African Americans. In another case, it was there's a group that's also being discriminated against. Hernandez was sentenced. All right, so in that last sentence that I wrote, what do you notice that I included? Yes, segregation. And yes, a quote, right? So segregation, yes, that ties back into Brown versus Board of Education. And a quote, so they can see that I'm pulling straight from that description they gave me. They told me, use your knowledge of the required case and pull from the stuff that we're giving you. So if I'm pulling a quote, that shows I obviously read the thing, right? So, and now the other thing though, you can't just drop a quote and then be like, okay, I'm done. You need to be able to explain that quote. So we said that the courthouse itself practiced segregation in its facilities. And then you could expand on that by saying, as no Mexican, or as no one of Mexican American ancestry had served jury in over 25 years. So now you've provided a solid foundation for Brown versus Board of Education and for Texas versus Hernandez. Now your next job, like it said up here in Part B, is to explain how they led to a similar decision in both cases. So what you can do here is say, similar to Brown versus Board, a minority group, right? In one case it was African Americans, in another case Mexican Americans, was facing segregation and discrimination because of race in schools with Brown and in the courthouse. Now we've kind of established our clear link. So we've said, here's the stuff about Brown, here's the stuff about Hernandez, here's a statement about why they're related, right? The next thing we can do is add more detail to it. So what's some more detail that you could add that ties these two in together? Specifically looking at the Constitution. So far you've really just focused on facts, right? Or we've just really focused on facts. We haven't really addressed how it ties back into that equal protection clause. So what are some things you could add so that it would tie back in directly with equal protection clause? I'll just keep typing and then you guys can add ideas as we go, if that's okay. So one thing you could say is that based on these facts, in both cases, both groups were not being given equal protection under the law, right? This is another place where you're showing that you have constitutional understanding, which is what a College Board is looking for. Therefore, a violation of the 14th Amendment. So, therefore, in both cases, the court ruled in favor of the minority group. I appreciate whoever is correcting my grammar and spelling and bad typing errors. If you read this last concluding sentence of my response, what are some things you notice? Yeah, so 14th Amendment of the Constitution guarantees equal protection to all citizens of the United States. You can definitely add that in right there. Easily just get rid of that. Therefore, start typing that. So what do you notice about those last few concluding sentences about the response? Yes, there's comparison, right? If you, sometimes it's hard when you have you're writing this FRQ, sometimes you get so caught up in writing, you forget what the question is asking. Okay, so if you go back up here, it says explain how the facts in both cases led to a similar decision, right? So at the end, I'm talking about how there was clearly a link between the way in which those cases were decided, if that makes sense. Okay? So we have part B done. Now we have to do part C. So I already see some ideas up here about stuff that interest groups could do. So courts are discriminating against him, correct? And I think that would go more in terms of part B, right? Yes. And yes, the interest group could write an amicus curiae brief to prompt the court to apply similar decisions as in Hernandez versus Texas. So what is an amicus curiae brief? If you guys want to answer that in the chat or in the document. Isn't this a bit long? Will we have enough time on the test to write all this? Yes, it is a bit long. But if I tell you a secret, all of this that I'm writing, a lot of it is just taken from my own response that I wrote for the exam. So it's really not that much if you know the information. Also, this year it's going to be typing. So, like, I mean, this is taking us like 12, 13 minutes. And that's with us discussing. So, really, if you know it, it shouldn't be too bad. Okay. Coronavirus. As long as you, normally, if it's a case you understand and you know a lot about it, the first part, the introduction part, is going to be really easy, especially if it's you just typing. You're just going to have to give a little spiel about what the case is about. Then you're going to have to summarize the information College Board is giving you in terms of the new case. Then you're going to have to link it together. So if you know, really, if you know your information from the required cases, know how to read and summarize with the stuff they give you and compare and contrast, it'll be not too bad. Okay. Yes. If this is the only FRQ, I think you guys could definitely finish this in 45 minutes. I don't remember the time limit for this. Or when it was last year, I honestly don't remember what the 4 FRQs, wasn't it like only an hour or an hour 30 to finish all 4 FRQs? So I think it was, yeah, I think it was 45, I think it was 75 minutes. I could be wrong, but it was somewhere where they were telling you to spend 20, 40, 60. It might have been 90 minutes. It might have been an hour and a half. So I think they suggested you spend 20 minutes on the first 3 and 40 minutes on the last one. So if that's the pace you're going at, hopefully this shouldn't be too bad. Okay, off track. Part C, we're talking about interest groups, right? Yes, Amicus Curiae briefs, those are friends of the court. So those are when people outside of the judicial branch are writing to the court trying to influence the decisions. President Obama has written in an Amicus Curiae brief. The public can write Amicus Curiae briefs. Okay, these are all people that are outside of the court that are writing these briefs. Okay, another thing that interest groups could do, that's a key thing. If you know anything about interest groups, you should know this, is that they can lobby, right? An interest group could lobby a legislator in Congress to expand civil rights, as in Hernandez versus Texas. This is perfect, right? This is correct. So, which one do you guys want to do? Lobbying, or we can go on the Amicus Curiae briefs. Either one is fine. All right, so lobbying. Second one is lobbying, right? Okay. So what you could say is an interest group. Again, try to use the wording of the question. So the question said, how does an interest group, how could they use the decision to advance their agenda? So advancing their agenda, that means like trying to push their issues, right? So if you use the wording from their question, an interest group could use the decision versus Texas. What did we say before? Lobbying congressmen, right? Or lobbying legislators in Congress to pass legislation that will pass legislation. Okay, so we could say to expand civil rights. That's one thing. So a lot of interest groups, their focus is on expanding civil rights. What other things could we lobby a legislator to do or make them do a specific action? What's something that, yes, especially for minorities, I can add that. Yes, laws. So legislators are the ones that can pass laws, right? So to expand civil rights, especially for minority groups. They could also lobby congressmen, pass legislation that would prohibit. So what's something, this is kind of something that I'm adding, but we're trying to be as specific as possible. So what's like a specific piece of legislation that you could come up with out of your head that would push their agenda or that would advance their agenda if we're talking about these minority rights? What could that legislation entail? Right, DACA, that's a really good example. But DACA is good to use if you can really talk about it. But if you can't talk about it, I would refrain from using a specific law and really just kind of coming up with the generalized law and say a legislator could do this, because it's not really asking what has happened, it's asking what could happen. So one thing that like I could come up with is like they could lobby congressmen to pass legislation that would prohibit using race to choose jury members. Now, this is going to relate straight back to that Hernandez case, right? So I could say this would expand upon the decision made in Hernandez versus Texas and allow for, let's say, stricter restrictions when using race as a factor, right? So now I've kind of made a good point, right? I've brought in a key political concept, a term that College Board probably wants you to know, lobbying, right? And then I've also connected it right back to my case. So I made a law that said you can't use race to choose jury members. Now that probably already exists somewhere or in some shape or form through our Constitution or through other laws that have been passed. However, this is just something theoretical that you're proposing, right? For the purpose of your free response. Now, this is really good because you're tying it straight back in to the decision that was made in the case that they gave you a whole summary about in the FRQ. So the last thing that you want to do is, again, go back to the question. And the question said, let's see, how they could use it to advance their agenda, right? So now I could use that same wording and say this could advance the agenda of interest groups that focus on protections for, let's say, accused criminals, right? So for those that focus on the rights for minorities. So that's kind of, again, straight from our little case explanation from before. And then, I mean, that's basically all you need, because in this case, even though this explain is shorter than the last one, basically all you're doing is explaining exactly how these two things tie in together and how this proposed legislation would work, right? So does that make sense? Basically the process that we went through in terms of writing this FRQ. Yes, okay. So the last thing we're gonna do, I know the stream is running long, is I'm going to go back to the presentation and we will look at some people that have that wrote responses on these, and we'll see the scores that they got. Okay, so you guys can definitely make a copy of this document if you want to. Obviously this stream will be live, or the replay will be there, but I'm gonna go back to the presentation. So the stream's not over yet, don't leave. It's almost over. Give me a second to get this presentation pulled back up. So we talked about all of this. This is College Board scoring guidelines. So this is basically what they said you need to have in your response for them to give you credit. If you don't have what's here, they're not going to give you credit on the exam. So part A, that was, remember, the identify. So all you needed in your response was that equal protection clause is what connected those two cases in terms of the 14th Amendment. Note that due process clause, like they have right here, due process clause does not earn the point for this. So make sure you're remembering that, okay? Part B, so this was your explain. This is where the bulk of your points is gonna come from, because this is where you're showing that you studied those previous Supreme Court cases, okay? So here, the first point is earned for describing a relevant case from the required cases. So Brown was about segregated schools, racial discrimination in schools. So you have to provide, like I said before, you have to provide that knowledge that shows that you really studied Brown versus Board and you know the facts behind the case. Okay, the second point is earned for correctly explaining how the facts of the cases led to a similar decision. So we address this in our response, right? The kind of the example that College Board gives is that with Brown, segregated schools led to discrimination, violation of equal protection. Hernandez, discrimination against Mexican Americans in jury service, violation of equal protection. So both cases, they're again tying that back in together, that equal protection clause, right? So hopefully that makes sense. Now the next thing, part C, was the interest group. So part A was kind of like, okay, do you know it or not? Part B was like the explain, so that was like the bulk. Then part C is kind of tying it to something else in the course. Okay, Japesh. Does College Board penalize for wrong answers? Like, let's say I say the correct answer, but I also add an incorrect segment. Would they take off points? Yeah, honestly, I think depends on how incorrect you are. If you say like Brown versus Board of Education had to do with segregation and racial discrimination, this violates the Establishment Clause of the First Amendment. Now, that's going to be like all you needed really was that first part that was right. But if you suddenly go in and say it violated the Establishment Clause of the First Amendment, that has nothing to do even with the case, I would be, I don't know, skeptical that you would get that point. Because really the College Board, what they say is that when they're unsure with the readers that a point should be given or not, they look at they take a holistic review. So they look at the rest of your responses and see, do you think your exam or enough, and kind of base their decision on that. I think they're going to be more lenient this year. Honestly, no idea. I don't know how they're going to do all of this test security with it being online and at home. Like, I don't know if that will affect their leniency, but I don't know. Well, I guess we'll see. Oh, sorry, I did not answer your question. So is this a perfect answer to the bare minimum? This is a bare minimum. And it can also be the perfect answer. If you have these things in your exam response, you will get all 4 points, right? However, if you expand on these, and let's say you missed something somewhere else, like I was talking about before, you said a few incorrect things, it might lead you to lose less points than if you had just kind of said it flat out. It's almost like you're showing your work in math if you have the work right, but then, hopefully that makes sense. It just, yes, if you think you are correct, this is the bare minimum and it's a perfect answer, okay? With Part C, again, we talked about Amicus Curiae briefs. That's something they could do, lobbying members of Congress, and they could sponsor a court case, encouraging the court to apply the decision in Hernandez. So if they wanted to do something further like that, directly dealing with the judicial branch. Now let's look at the scoring statistics from last year. The maximum number of points, it was 1 point for that Part A, 2 points for Part B, and 1 point for Part C. The mean score was about 1 3/4. Okay, so right around half. Honestly, AP Government, sometimes these scores are, well, really all of the scores, they're kind of skewed just because AP Government might be the first class, AP class you're taking. A lot of freshmen take this class, I know. So that's why the mean score might be less. But know that if you're getting that Part A and Part C, or let's say you're getting Part B right, the part where you're just recalling your previous information that and you're summarizing the stuff that they've given you, you're already more than the mean score, okay? So if, let's say, you can't remember that Part C, which ties back into another political concept, it is okay. You're not going to get a 1 just because you forgot that one part, okay? This is like a sample response that got all 4 points. So if you guys want to read it, I can stop, but if you don't want to, I can keep going. This is going to be in the replay. But basically, you can see that this person, they kind of, like you said, like someone said a few minutes ago, they kind of just wrote the bare minimum, but they got all the points because they addressed everything that College Board wanted them to address. So here they basically said equal protection clause is what connects them both. For Part B, I know it's hard to read. I can barely read it. It's in front of me because of this person's handwriting. But they again kind of talked about it being discriminatory in both lenses, and they gave a specific fact for Brown. Yes, concise is better. Don't go writing tons of paragraphs, especially if you know this is not your best case, or might not be not everything is going to be factually correct. So concise, yes, is better. If you guys want to read this is also available on College Board's website with their AP Government response. Then if you look at theirs, Part C is actually longer than Part B. So in theirs, they talked about how interest groups could use their decision to bring another trial case to court. So that's the third thing that College Board said was okay that we didn't really talk about. We talked about Amicus Curiae briefs and lobbying. This person talked about how they could bring another case to court. And then additionally, they also talked about this Amicus Curiae brief thing. Okay, so that is all that I have. Make sure to check out Fileable's website so that you know what the upcoming streams are. Again, thank you for coming. I really appreciate all the participation. Thanks, everyone. Bye.